Okay, welcome everyone to our task force meeting. As you know, today we will be covering non-payments in the time of COVID-19. The pandemic has shaken up every facet of our lives, and the housing court is no exception. Today we will learn the changes in the court and find what resources tenants might have to defend themselves. We will start with a presentation, and then we will go on to a Q&A at the end. Please hold on to your questions and refrain from using any case-specific questions. If you need further assistance with your own case, you can call our hotline at 212-962-4795. Before we move on, if you'd like to stay up to date with what we're going on in court answers, any updates with the court system, you can follow us on Twitter. We post daily information pertinent to the tenants in New York City throughout the city. Or if you miss a training or you would like to revisit some of the topics we discuss here, you can go onto our website or our YouTube as we record all of our trainings here. But without further ado, I would like to introduce you to our presenters. Today we are joined by Morgan Mayer, who is a third-year student at the NYU Law in the Housing Clinic. Next, we have Bill Baker, who is a second-year student at the NYU Law School. He is also in the Housing Clinic. And finally, we have Satish Nori, the head attorney at the Legal Aid Society in Queens. He is also the teacher of our young presenters ahead of us. And he also sits at the board of us here at Housing Court Answers. So please, without further ado, I thank you guys for coming and present us, and we are glad to have you here to teach us.
Thank you, Kayla, and thanks everyone for joining us today. What I want to stress before we begin is what we will describe today is subject to change. We are in a very fluid environment. The rules and the procedures are changing almost every day. And so what we will tell you about today may change tomorrow or next week or in a month. So keep that in mind. And at the end of the presentation, which will last about 45 minutes to an hour, we will be happy to answer any questions that you may have. Okay, so with that, I'm going to turn it over to Bill and Morgan.
Okay, so hi everyone. I'm Morgan, and as you know, Bill will be presenting with me, and we're going to be focusing on COVID changes kind of in the housing court, housing world sphere. So take it away, Bill.
Hey, thanks. So the first thing that one needs to know when a housing court issue is at stake is what sort of housing an individual lives in. What sort of housing an individual lives in determines a lot of their rights. There are a lot of different types of housing in New York, and it can get complicated. The major ones are listed here: rent stabilized housing, NYCHA housing, Section 8, which is also called voucher or public housing. There's also unregulated apartments, which includes illegal units. And then finally, some individuals are in condos and co-ops, although that's a little rare. So just to go into a little bit more depth, about a third of New York apartments are unregulated, which means that there is no law dictating what sort of rent a landlord can charge. A landlord can charge whatever the market will bear. There are regulations related to if a landlord can push a person out and how they do that. But in terms of the rent, the landlord can charge whatever they want for rent. About a third of New York apartments are rent regulated or rent stabilized. And sometimes the language around this can be mixed up. But basically, it means that there is a city limit on how much an individual can be charged to live in an apartment or in a housing situation. And about a third of New York apartments are owner occupied. Obviously, these numbers are a little bit low. And then about a tenth of New York apartments are subject to regulations other than rent stabilization, which means that it's either Section 8, which is the federal program for public housing, NYCHA or HUD, so they either get a voucher for public housing, or they actually live in what's called project-based housing. They actually live in a facility that's administered by, or a housing situation that's administered by NYCHA itself.
So as Bill kind of alluded to in the previous slide, there's rent stabilization or regulated housing. And this provides three major rights for tenants. And the policy is kind of supposed to be somewhat mirroring homeowner stability, wanting to provide a little bit more security and kind of roots. So the first one is the right to renewal. So if you think about kind of unregulated housing, which is maybe what people have most experience with, once your lease ends, it's kind of up to the landlord or up to you to decide if you want to renew that lease, but there's no kind of default that that lease will be renewed. But rent stabilization is different. So the landlord can't end the lease without cause, meaning that there's that default, there's that presumption that the lease will be renewed for another set of time. There's also kind of what everyone would think of when they hear rent stabilization, but limitations on what the landlord can charge in rent. And then the last right is succession. So depending on, there's like a few specific rules and regulations, but you can pass that rent regulated apartment onto family members that were living with you. And family members are also defined more broadly, not just kind of sister, brother, mother, father. So a question you may be asking then is, how do I know if my building is rent stabilized? There's kind of three things you can just look for. So is your building built before 1974? Are there 6 or more apartments in the building? And is your rent not an even number? So if you're paying like $1,100 a month in rent, this most likely won't be rent stabilization, because rent stabilization works with every year the increase of a percentage on a rent. And so you get kind of these weird numbers like 53 cents at the end, or ending like 11,057, something like that. So those are kind of the three major checkpoints you can look at. But if you want to know for sure, you can write to HCR and you can request a rent history, or you can call 311. You can also, and we'll talk about this a little later, but HCR isn't just for rent stabilization. You can also use it for other things. And you can also try to find out, if it's rent stabilized, how much your rent should be. So the Housing Stability and Tenant Protection Act, or you may see it as HSTPA, was enacted in 2019, and it sets a lot of rights for tenants in New York. And it made a lot of changes kind of encompassing a lot of housing law. But there are some changes that specifically go to rent stabilization. So we'll talk about those. First, there's something called a legal rate and then a preferential rate. And so a legal rate is the top amount that a landlord can charge. And then a preferential rate is something that a landlord is charging that is under that legal rate. So it used to be that landlords could offer a tenant a preferential rate, get them into that lease, and then change the preferential rate midway through the lease. And as you can tell, it seems to go against the policy of rent stabilization, because it doesn't provide that much stability, and it would make a tenant nervous that when is this going to be changed? So the HSTPA made sure that you can't change preferential rates mid-lease anymore. You have to wait till the end of that lease. It also gets rid of two other things that go against this rent stabilization policy. One is the vacancy bonus. So landlords used to get a bonus for having, or there was like an incentive to have empty units. And so now there's no incentive. And then there was also something called owner use, which is when the landlord could use those units for herself, himself, or any family members. And so the HSTPA has made sure that isn't happening anymore either.
And let me just clarify that now, after the HSTPA, if you have a preferential rent, the preferential rent now becomes the legal rent. And I think someone just put that in the chat. So if you see a rent that is lower than what the legal rent is, that low rent is now the legal rent, thanks to the HSTPA. So that's a really important point to note.
Thanks for clarifying, Satish. Next, we'll cover Section 8 and NYCHA. So Section 8 is a federal program. It's administered by HUD. And NYCHA is the city administrator for that federal program, that Section 8 public housing program. This covers both vouchers and public housing. The public housing has a waiting list and can be difficult to get into, so the vouchers might be more common. But the thing that they have in common is that both any Section 8 recipient pays no more than 30% of their income towards rent. There are also some different protections for Section 8 and NYCHA tenants, but they can still be evicted for non-payment. And so it's important to note that that doesn't just protect them. And then the last bucket of housing that we'll talk about is unregulated housing. So in unregulated housing, landlords are free to charge any rate they want. They can refuse to renew an individual's lease. They still have to notify the individual if they're going to break the lease. They can't evict during the lease unless they have something like a non-payment case that they're bringing. But it's sort of the Wild West in terms of how much a landlord wants to charge or raise the rent by. All agreements to house are valid. That includes paper leases and oral agreements. They're no less valid. And those can be year-long or month-to-month arrangements. All of it is legal. Their unregulated units also covers illegal units. So basements, cellars, and attics that the Department of Buildings or another administration in the city, administrative authority in the city has decided aren't habitable. Often landlords will still try to rent out those spaces, and it leaves tenants in a very vulnerable position in terms of the city may push them out of that apartment, even though technically, legally, they do not have a lease because they're not legally allowed to live in that space. And because they don't legally have a lease, they can't pay rent or owe rent. So this is often a complicated and difficult area of housing law if a tenant lives in an illegal unit.
So there's a question in the chat. We might as well answer it now just because it's relevant to the slide. But before I answer, I would say that it's very important to find out if you're talking to a tenant who owes rent right now or anytime, whether their apartment might be illegal. And there's two reasons for that, as Bill mentioned. One, if the apartment is illegal, the landlord cannot collect rent by law. They can, but they're not allowed to, and they can't evict for non-payment of rent. So that's very important to know. And the second thing is, if the apartment's illegal, you may be very careful about advising a tenant to call 311. Because what we've been seeing lately is a tenant in an illegal apartment calls us and says, I have rats or I have leaks, and we say call 311, then HPD comes over and says, everybody out. This is an illegal apartment. No one can live here. And then the family just lost their home. And they would have rather lived in that home and negotiated with the landlord to get the conditions fixed than be in a shelter or worse. So be very careful if you're hearing from a tenant who might be in a basement or an attic or a garage or some illegal unit. The question is there unconscionable increases to market rates? So unfortunately, there are no limits to what a landlord in a market rate apartment can charge. That's why many in the tenant advocacy community are pushing for what's called good cause eviction. And these are laws that would protect unregulated tenants from increases that are unconscionable or would require the landlord to have some basis to evict a tenant. So we need to push our local legislators to pass good cause eviction, especially in places like Queens, where there are so many unregulated apartments, people living in two-family homes, people living in basements, and so on. The HSTPA does not prevent a increase on an unregulated apartment of any kind. Okay, so let's move on.
So now that we've gone over the bigger buckets of housing, we'll talk about housing court. So housing court originally was supposed to be kind of like a compromise to bring these housing cases in a quicker manner than civil court. But from what we've seen, and part of this may be because there wasn't a right to representation when it was initially started, was that this has become a shortcut for landlords to bring their cases more quickly. Tenants can still bring cases in housing court, but we just haven't seen those in the same numbers as landlords are bringing these cases. Right now, we're seeing it's being used heavily for evictions. So, and like I said, since it's kind of supposed to be a compromise and maybe a shortcut for these claims can still be brought in civil court, but housing court is sometimes seen as the better alternative because it's quicker. So it was created at a time when there was no right to representation. And so some of the rules that surround housing court kind of have to do with that. So the first bullet point you see, pleadings have to be sufficiently clear. This is supposed to be, there shouldn't be too much legalese, there shouldn't be too much confusion because maybe someone isn't represented and you should be able to read the claim and know what you're being asked of, why you're going to court. But as many of you probably know, the right to counsel law was passed in 2017. And so before COVID, that was being rolled out kind of by zip code. But now for COVID relief, everyone qualifies. So everyone can call 311 and get representation.
So I'll kick off talking about non-pay. So non-payments are 85%, approximately 85% of the cases in housing court. The vast majority of proceedings in housing court are evictions or motions to evict tenants who haven't paid the rent or who are being accused of not paying the rent. A landlord only needs to show a few things to bring a tenant to court for not paying rent. All they need to really show is that they have a right to collect the rent. There's an agreement that is like they actually own the space, or they have some other agreement to collect the rent. There's an agreement on how much rent they actually should be collecting, and that the tenant actually didn't pay. These proceedings don't automatically result in eviction, even if the landlord proves that the tenant did not pay. There are several programs through the city that offer assistance to tenants who are brought into non-payment proceedings. There's FEPS and city FEPS, which are a little bit confusingly named, but they're different programs. FEPS is for families with at least one child under 18, and they'll pay rental arrears as well as an ongoing rental supplement for families who can show rent assistance need. City FEPS is for families, as well as it's like an amalgamation of a bunch of different programs that used to exist under different names in the city. Certain cash assistance programs, vets, people who are coming out of shelters, people who are disabled, all of them will probably fall under city FEPS, which will pay arrears as well as a rental supplement as well for those who can show need. And finally, there's a one-shot, which is an emergency grant from the HRA to help individuals pay arrears. It's not an ongoing rental assistance. They are technically loans, but there is no interest rate, and the amount that tenants are expected to pay back is extremely low. It could be as low as $5 a month. It's meant to be very accessible. Yeah, I think that all of these programs, the thing that's important to know is that there are requirements of showing of papers and showing of need that can sometimes be difficult for certain clients to actually meet. And so understanding what they actually have to show for each of these programs is important.
A couple of things that I would add is one-shot deals are now being granted, at least we've had one or two cases in which HRA granted the one-shot without a housing court case. So that's really important to know. You might be able to get rent arrears even if your client has not been sued yet by their landlord. And so take advantage, try to advocate to get the money before the lawsuit, because that can save your client a lot of stress and heartache and aggravation. And the second thing is HRA is probably likely to pay more and under more tenuous circumstances now than they ever have before. They don't want anyone homeless. They don't want anyone outside in a pandemic, because that's going to be on them. So be creative, ask for money that you maybe didn't think you could get before. Future ability to pay is another element of a one-shot deal, meaning does your client have the ability to afford the rent in the future? And even things like that maybe can be more flexible now, because right now, very few people have future ability to pay, or many don't have future ability to pay, but hopefully they will next year when businesses open up again, when the city opens up again. And so I think HRA is aware of that. People may not have future ability right now, but if you can make a case that they will have future ability when the pandemic is over, that's really all HRA can ask for. What else can they do? What else can anyone do right now? So bottom line is be creative, push harder than you have before, because you might get that one-shot deal granted, even if you wouldn't have before COVID.
Great. So we'll move to holdover cases. And this is another type of case a landlord can bring against a tenant. And it's basically demanding possession of an apartment for another reason other than non-payment. And so I said a landlord can bring it against a tenant, but it doesn't have to be a tenant. So if there is a landlord-tenant relationship, holdovers can be brought for cause or without cause at the end of a lease term, but like we said, in unregulated apartments, because for rent stabilization, you have that presumption of re-upping. And then if there's no landlord-tenant relationship, you still must be given notice for this holdover case, and that's 10 days. And this would be like in a squatter type situation. So there have been some notice changes from the HSTPA, again, to protect those tenants. You need, for non-payment cases, you get 14 days, and it has to be sufficiently detailed. And then with certified mail, you have to get it within 5 days of the due date of rent. And just something to keep in mind is that if the notice is incorrect, if they call a defect in the notice, the proceeding will be dismissed. So it's really important that tenants get the correct notice. And if you think about it, it makes sense, because housing court was made without this right to representation. And so tenants need to know what is being expected of them, and it needs to be clear. There's also been notice changes in holdover cases, and that's based on how long a tenant has lived there. So you get 30 days for if you've lived there for less than a year, 60 days for 1 year, and then 90 days for over 2 years. So as we talked about, tenants can also bring proceedings into housing court. Tenants can sue landlords for repairs or maintenance in what are called HP actions. This is for a lot of things. I put hot water and heat down as examples, but you can probably think of a lot more, and you've seen a lot more. Tenants can also sue landlords for harassment, and this isn't just threats. This can be kind of any sort of disruption that rises to this level. So it's like turning off heat and water, tampering with doors or locks. It can be like noises, like doing construction at night. A lot of this harassment is in the sense of basically making it hard for the tenant to live there and maybe trying to get the tenant out in an illegal way. And then the last one is illegal lockout proceedings. So in New York, there's a law against landlord self-help, which is if the landlord were to change the locks or to throw out the tenant's stuff without going to court first. So the landlord has to go to court and take the tenant to court to get that eviction. They can't just, and as they call it, self-help, they can't just change the locks. So maybe there's a question of how do you file an HP? What are the logistics? So here's the website. Here's a website that's really helpful, justfix.nyc. And so if you go there, you just make a quick account. So it's like your name and your address. And then you can check off all of the conditions that you want to be fixed. And what they'll actually do is they'll send a free letter in certified mail to your landlord. And it's kind of written up in a little bit of legalese. It's like sounding very nice. And it also gives the landlord the civil penalties, hoping for an enforcement. And then there's also, so maybe you think, well, it's not worth it because the landlord won't listen, but this is also kind of a good way to put it on record that you've said, like, these are the things that are wrong with my apartment.
Shall we go to Just Fix just to show what it looks like?
Sure.
I think that link should work. Okay, so I hope many of you have already used Just Fix. And full disclosure, I'm on the board of Just Fix, so, but I don't make any money from it. It's a nonprofit. So there's a few things here that are very, very helpful. Number one, I talked earlier about illegal units and the fear of calling the city to complain about conditions at an illegal unit. Well, one alternative is to use Just Fix to start a letter to send to your landlord about the conditions. And that letter doesn't go to the city. So you can tell your landlord, fix this condition without risking a vacate order from HPD or DOB. The second thing that is new after COVID is you can start a case to sue your landlord for repairs from your phone. Let me repeat, you can start a case to sue your landlord for repairs from your phone. And you do that by clicking this button that says Start My Legal Case. Now, this was not true before COVID. It's only true because the courts are closed. And fortunately, this will continue to be true even after the courts reopen. So for many tenants who have to take time off work or travel long distances or take their kids out of school just to go complain about a leak or a roach infestation, now they can start a case from their phone and bring their landlord to court virtually. So that's a big deal. And the third thing that I want to point out is what's called Who Owns What. Many of you who are tenant organizers or advocates may have used this, but if you don't know about it, it's a really great way to find out what your landlord owns, who your landlord is or who a landlord is, how big their portfolio is, how much of their portfolio is rent regulated, where in the city their buildings are located, what their address is, where they pay the taxes from. All of this is publicly available information, but it's aggregated into one place here. So these are great tools to use. They're all free. Anyone can use them, and they're built for our clients to use on their own. So please check them out. I think you can use them and our clients can use them to get a lot of help.
Yeah, it's a cool website. So to get down to what's changed during COVID, as we said, things are really in flux. Things are changing every day in terms of the way that the court is operating. And so this is just a snapshot in time. Obviously, cases are spiking, but maybe it's decelerating, but maybe it'll get worse during Thanksgiving. And there's a lot of different things that are changing politically at the same time. As of this moment, here's what's going on. The courts have reopened in a limited capacity. They effectively stopped operating in March. They opened in a limited capacity in September, and they were only hearing emergency matters from the tenant side. So illegal lockouts, tenants who could not get into their living situations, and serious repairs were the only things, HP cases were the only things that were being heard. Evictions were also stayed entirely through October. That is not true anymore. And the situation is now more fluid and more complicated. Non-payments from before COVID are back in court and being heard, and potentially if a tenant was found to have not paid before COVID or has a pre-existing case from before mid-March, they run the risk of potentially having a court case and being evicted. The court has also expanded e-filing, but the hearings are in flux. Sometimes, like, some of them are online, some of them have been in person. There's no new in-person things going on as of like last week, but socially distanced court conferences that are ongoing are continuing, and they're sort of just flying by the seat of their pants in terms of how much is digital and when and why. Landlords now have to ask for enforcement. They have to go to the court to ask for enforcement of judgments that they received pre-COVID. So I have an example here to sort of illustrate what kind of case this is talking about. And these are tenants who are at high risk now of being evicted or being evicted in the near future. So if a tenant was given 3 months to make rental arrears in March, the landlord, and they failed to do so, the landlord now has to go back to the court to actually ask that the tenant be evicted in a motion that's called DRP 213. So because of universal representation, now all tenants are going to get a lawyer when they're faced with this situation, but these proceedings could lead to evictions as soon as next month or even sooner. It's really unclear. And landlords are trying to get around these requirements and these restrictions. They're actively trying to do so. There's a trick that we saw recently in a case called the current rent provision, which is landlords ask that if a tenant receives a grant for rental arrears, they use an accounting trick to apply it to the current month before they apply it to the arrears. And so if a tenant is unable to pay, they basically, their rental arrears are going towards their current month's payment, and they keep falling, they remain far behind on their rent payments. So landlords are trying all sorts of tricks to get around these things.
One thing that I can add here is today I learned that the first eviction has already taken place in the post-COVID era, and it was in Brooklyn. I don't know much more than that, but just be warned that evictions are taking place. They can happen right now. And so don't take anything for granted. If you have any doubt, call a lawyer or call Housing Court Answers, call 311, try to get connected to the housing hotline. Don't take anything for granted. Evictions are happening right now.
Yeah, I didn't realize there was an eviction today. I haven't been following. Wow, okay. So in New York, there's this law called the Tenant Safe Harbor Act, which is in force. It's in force for the length of the COVID emergency. So as long as there's a state of emergency around the pandemic in the state of New York, the Tenant Safe Harbor Act is in force. The Tenant Safe Harbor Act allows tenants to apply for non-payment eviction relief. So instead of the blanket moratorium that was on evictions that was in force before, up until last month, now tenants have to apply for relief from eviction. This just applies to non-pay cases. So no other cases where a tenant could be evicted. This doesn't apply to any of those, just non-payment. And they still owe rent for the duration of the COVID emergency. So even though they can apply for eviction relief, they won't be evicted, they still owe the rent. And so when the emergency comes to an end, there is a worry that all this rent will come due for certain tenants and lead to a flood of cases in housing court. That's definitely a fear that we have. And we talked about the one shot, but one shots are being doled out with restrictions, and it can be hard for certain tenants to show that they actually have that need. But as Satish said, apparently they're a little bit more lenient right now. There was also a $100 million state rent relief fund that made the news in the summer. Most applicants were denied. I actually read an article on this last night. Nearly 100,000 tenants applied for state rent relief and 15,000 received them, so around 15%, with a number of them still pending. And millions of dollars out of this pool have also gone unspent. So there have been a lot of different efforts in New York that have been of varying use to tenants who are suffering. The Tenant Safe Harbor Act, as I said, only protects against evictions for rent owed during COVID, which is why rent from, and the application for the rent relief has ended. The Tenant Safe Harbor Act, it only protects from evictions for rent owed during COVID. So tenants not only still owe that rent during COVID, they're just immune from being evicted if they can show hardship. It also doesn't apply to rent that was owed before COVID, which is why evictions are starting to happen for people who owed rent before the courts shut down in March. Some examples of COVID hardship that a tenant can use to show to apply for eviction relief. Showing of diminished income during COVID, showing of the receipt of public benefits during COVID, and also medical and funeral expenses. Showing of medical and funeral expenses can apply. And the last form of protections that some of you might have heard about is the CARES Act protections. The CARES Act instituted a moratorium on evictions from many types of federally administered and federally subsidized public housing. That protection is over. That protection expired in July. Tenants are still subject to the state restrictions on evictions, but no longer protected from eviction for the CARES Act. There is also a lingering issue of tenants are supposed to be exempt from late fees stemming from the period during which the CARES Act moratorium was in force. So there is that relief that might still apply to some people out there.
So I'm sure, as everyone's kind of maybe like vaguely heard about, the CDC itself dropped a moratorium that surprised a lot of us. And this was a moratorium on evictions until January if the tenant similarly can prove financial hardship from COVID. So the CDC basically gave the reason that homelessness and housing insecurity is really bad for public health, which I'm sure we all can make that connection. It was just surprising that they put that memo out there. But tenants do need to sign an affidavit, which I'll show in the next few slides, kind of affirming to the fact that the financial hardship is from COVID and that they've tried all other avenues and that if they are evicted, they will basically be out on the streets. And an important note is that this doesn't actually forgive any rent, it just puts off the eviction. So it's exactly like Bill was saying, where once this expires, there may just be a rash of evictions in housing court. So it's just kind of like a stopgate, a Band-Aid for right now. But again, just like to keep in mind that one shot from HRA maybe is applicable with restrictions. And then another kind of wrinkle is that it's set to expire on January 3rd. And then as we all know, Biden's sworn in on January 20th. It's kind of unclear if like Biden will extend protections, but even if he chooses to do so, there's that gap of time between the 3rd and the 20th where we don't really know what's going to happen. So here's the first part of the affidavit. And you can just Google CDC affidavit and this will come right up. But basically, like I was saying, you have to show that you've done everything you can. You've applied for governmental assistance. You have to certify that your income is below a certain level or a slightly higher level if you're filing a joint tax return. Your substantial household loss or financial hardship is due to COVID and you're trying every avenue you can think of. And then just similar affirmations that you're understanding, basically that this is like isn't rent forgiveness. And if you did need to leave that you would have to either go to a homeless shelter or be in close quarters with people. Tying back to that, it's very dangerous for public health right now for people to be housing insecure. So we briefly wanted to just mention too the rent striking movement, which we saw spring and early summer, but it kind of has tapered off. And a lot of that is because of some of these band-aids that we've seen. So the moratorium on evictions, the Tenant Safe Harbor Act, and the closing of housing court. And it's kind of hard to say what's going to happen with this because as we've all been saying, it's just like very unclear what's going to be happening. There's a lot of instability. Things are changing every day. And maybe some of these protections that we've mentioned from COVID will stay, others probably won't. So it's just very hard to tell what this means for this movement. So major takeaways from COVID changes in general. There are some protections for some tenants, but obviously they don't extend as far as we would like. And you see there are evictions beginning against it, like we've seen there are evictions beginning. So kind of big ticket issues. The biggest thing is don't ignore court papers. We want to make sure people are checking their mail, even if they're not living at that place right now because of whatever COVID situation they have going on. We want to make sure that court papers are being seen and being seen soon. And again, we just want to over-mention that this is changing daily. And so it's very hard to say exactly what it looks like and how long it's going to look like that. But we do have resources. So you can go to legalaidnyc.org, you can call 311, you can call the Legal Services Housing Hotline. But we want to make sure that people are wary that evictions are starting.
Okay, let's open it up for any questions about the presentation or anything at all related to housing.
So I've taken some questions and I put them on a separate note, so I'll read them off. But if anyone has any more questions, please put them in the chat box and I'll add it to the queue. And so the first question I have here is, and you explained it a little bit before, but maybe we can go into more details. What is a group HP action? It asks, is this like a discount for tenants associations and so forth? So if you could go on to that and how maybe tenants can apply. How can tenants start a group HP action?
Yeah, so it's not like a Groupon. It's more like a bunch of people getting together, usually with a tenant organizer, and suing their landlord. So recently in Queens, we filed a group HP against a landlord in Astoria who turned the heat off in the building. And a group HP means 5 or 6 of the tenants in a building of about 15 filed a suit together, all as one, and said, we're all facing the same problems. Judge, please make the landlord address these issues. And the more people you have in the group, the more powerful the case is, because if 5 or 10 or 15 people are all saying the same thing, it's a lot harder for the landlord to say it's not true. There's much more evidence in the form of testimony and more violations, hopefully, that HPD issues, and it's just more believable. Why would a bunch of people go through the effort of suing and going to court and spending time if it's not true? They obviously have a need. So if you know of or hear of a tenant in a building and their neighbors are facing the same issues, try to find an organizer or call a legal services office and see if you can get them all together and file a case together against the landlord. It's no different from filing an individual case, it just has more names on it. And it gets more attention, and it's easier to get the results that you're seeking if there's more petitioners involved.
Okay, so I see here that we have some more questions that are related to the HP action, so I'll just hit them up first. If there are similar issues across multiple buildings with the same landlord, can they do a group HP or just people within the same building?
Yeah, it's a great question. Unfortunately, you can only sue for a particular building, but that doesn't mean that multiple tenants in different buildings owned by the same landlord can't have a press conference together, can't file cases on the same day, can't protest in front of the landlord's offices all together. But in terms of filing the case, you can only file a case against a particular building, and only those who live in that building can join that particular case. So another question is, do all the tenants have to go to court? No, they don't all have to go to court. And most of the early court dates are just going to be procedural, and they're going to be postponed. And also, most of the court appearances are now virtual. Because of the spike in COVID recently, and because of several people in various courthouses getting COVID, I think the courts are going to really shut down any kind of in-person appearances very soon. There's already no virtual trials, in-person trials anymore. So it's easier for tenants to sue and appear on a video camera, a webcam through Microsoft Teams than it used to be, where all the tenants had to go sit in court and wait for the case to be called. But any one tenant can push the case forward. And if there's a day in which the judge wants to hear from everybody, on that day, people should be ready.
And so the next one is, what is the protocol for bringing an HP action for harassment while a landlord has an ongoing non-payment case? I think that this one is kind of addressing how viable is it to start a harassment case that doesn't maybe look like it's retaliation for a non-payment case, or if the court will believe them, but you can interpret this however you want.
Yeah, so what is harassment? Harassment means anything that the landlord does to make a tenant feel like they have to leave the apartment. So harassment can be words, it can be threats, it can be actions like turning off the heat or the hot water or the electricity. It can be not collecting the rent. It can be just disappearing. And anything that the tenant feels the landlord is doing to make them leave the apartment. And so there's no harm in bringing a harassment case. You can bring a harassment case no matter what else is going on between you and the landlord. You can bring a harassment case if you owe rent. You can bring a harassment case even if you don't have a lease. You can bring a harassment case if the landlord's already suing you. There's no connection, there's separate matters. And sometimes bringing a harassment case can give you that extra leverage that you need to win the other case. And so there's no downside really to bringing a harassment case. And you can file one through JustFix the same way that you would file a case for repairs. It's very easy to do. And many people bring cases for repairs and for harassment together, because usually those two things come together.
We're going to move on to what is the difference between getting sued for non-payments in civil court versus housing court, and I guess just the different kind of ramifications if you lose in either of those different courts.
Yeah. So the funny thing about housing court is that it's a place where the landlord gets two benefits for the price of one. If you owe rent to your landlord, the landlord can sue you in housing court and get the money, or get a piece of paper that's called a judgment that says you owe the money, and they can take your apartment away. So if that sounds unfair, it's because it is. They get two things for the price of one. And so what the Tenant Safe Harbor Act did, and maybe this should be the law, wouldn't that be great going forward forever, is that if someone owes you money and they're a tenant and you're the landlord, you can collect that money, but you shouldn't be able to kick them out of the apartment. Why do landlords do that? Because they think the only way they get the money is if they threaten to evict someone. It's really just a vehicle to get the money that they think they won't get otherwise. So in civil court, in contrast to housing court, the cases are just about the debt. So imagine like a credit card debt or an unpaid bill of some kind. You can be sued in civil court, and the party that sues you gets a piece of paper that says you owe that money. And if they win, and if you don't pay it, they can collect that money from your bank account. and they can only take a certain amount at a time. They can't take your benefits, and they can't take your personal property, like your clothes. They can't take the clothes on your back, but they can collect money if you have it from your bank account. Many of our clients don't have money, and so they are what's called judgment proof. You can't take anything from them because they don't have anything. And so in housing court, many people who are sued and get judgments for money, they're irrelevant because the respondents, the tenants, are judgment proof. So the Tenant Safe Harbor Act basically says, if you owed money since March of 2020, after COVID started, for rent, the landlord can't take your apartment away for owing that rent. And that's a really good policy. However, as Bill mentioned, what's going to happen after COVID? Are the landlords going to start collecting judgments against tenants? What does a judgment do to someone? It ruins your credit. It makes it much harder for you possibly to find another apartment. It's also a burden and a stress. What if you eventually come into money or you start working again? It's a real burden to know that a portion of your paycheck every month is going to disappear because you owe this money to your old landlord. So we're really worried about what's going to happen after COVID with all of this money that landlords cannot evict people for right now.
And to go further into that, and I know that, we focus mostly on housing court, but let's say a tenant does get sued in the civil court instead of housing court, can they use similar defenses that they would use in housing court in the small claims or civil court?
Yes, that's a really good question. Many of the same defenses that would apply in housing court also apply in civil court. So you might say, like what? Well, number one, maybe you didn't get the papers properly. And in civil court, many people fail to get the papers. Putting it another way, the plaintiffs in civil court cases serve papers really badly. They just take shortcuts. They spend very little money, and they don't properly serve people. So that's a defense. If there are repairs, you can raise those and say, maybe I owe you rent, but you never gave me a proper functioning, safe, healthy, habitable apartment. So I don't owe you everything that you say. I owe you some portion of that, or maybe you owe me because I had to spend money on XYZ, like the fridge was broken, so I had to buy food elsewhere and so on. And finally, all the defenses that might apply to a contract claim would apply. Was there a contract, an agreement to pay? The person suing you, do they have the right to sue you? Are you judgment proof? Are they seeking to obtain benefits? Did they already take money out of your account, which they weren't entitled to? So I think I mentioned in the chat, but several organizations have consumer lawyers who can help with civil court cases. But one thing to note is if hundreds and hundreds of new people are sued in civil court, there aren't enough consumer lawyers to take on all those cases. So we're going to have a real problem, and we'll have to deal with that problem at that time.
Thank you. And so I know you addressed this a little bit, Morgan, but if we could maybe talk a little bit more about it. How do we expect the courts to respond to rent striking tenants who withheld during COVID because of the lack of funds? And what examples can tenants use to defend themselves once they do find themselves in court?
So what will the courts do about rent striking tenants? We don't know. It hasn't come up directly yet, partially because of all these other protections that tenants have. Many landlords have not brought cases for rent during the COVID period. When they do bring these cases, will it be a defense to say that I was part of a rent strike? Technically, it's not a legal defense to say that I joined with my neighbors to withhold the rent, right? It's not a legal defense, but is it something that courts will consider and maybe be sympathetic about? Hopefully, but there's no guarantee that that will be the case because judges are supposed to be following what's written in the law, no matter how they feel about it. And what's written in the law is if you live in an apartment and you agree to pay the rent and you don't pay it, then the landlord has a legal remedy against you. And it's not a defense to say that there was this movement that I decided to join because it was the right thing to do, right? So it's a really good question. And that's why part of the issue here is a cancel the rent movement or a rent assistance program. Either one of those things would help solve these problems. Cancel the rent means that the governor signs a law that says that any rent that was due from X date to Y date, let's say March until COVID's over, gets erased, that it can never be collected, that no one can ever be sued for it. And that's a big deal. That hasn't happened yet, even though there are bills on the table. The second thing that can happen is there could be a rent relief or rent assistance or a rent grant program. And the state tried that with the $100 million handed out by HCR, but it didn't work that well. And probably what we're going to need, and hopefully we'll see this, is a federal rental assistance program so that everyone gets X amount of money to start from scratch. This will help tenants, this will help the landlords, this will help small businesses that are in the communities where tenants and landlords live. Hopefully it'll have a huge impact on many of the problems that we're talking about today, but we're not there yet. And the other thing that I would note is, as Bill and Morgan mentioned, Joe Biden doesn't get sworn in until January 20th, I think at 12 noon. So between January 3rd, when the CDC moratorium expires, and January 20th at 11:59, people can be evicted. A lot of people can be evicted. And there's nothing Joe Biden can do about that because he's not the president yet. And Trump doesn't care. So we're really worried about what happens during that, 2.5 week period of time.
As COVID rates continue to rise in the city, do you think the court will close again? And will evictions be put an end to, especially as the winter during the pandemic approaches?
I have a hope that the courts will close. One way to look at it is if the schools are closed and restaurants are closed and indoor dining isn't happening, why would the courts be open? It just doesn't make any sense. And eventually logic will prevail and the courts will close and evictions will stop. Otherwise, it's just insanity to think that it's not safe enough for kids to go to school. It's not safe enough to get a slice of pizza inside a pizzeria, but it's safe for a marshal to come and lock you out of your apartment. It's safe to be sued and have to go into housing court to defend yourself. None of that makes any sense. So unfortunately, it might require a lot more people getting sick, and nobody wants to see that happen. But if that's the way it plays out, I'm really nervous about Thanksgiving and all the people who are traveling and all the people who are going to get sick. It just seems like it's inevitable at this point that the numbers are going to go up and there's going to be more lockdowns. And as a result of that, if there's any silver lining, it's that housing court will be closed again. Evictions will have to stop again, and we'll have a timeout until everybody gets back on their feet.
What should tenants know about the legal ramifications, if there are any, of signing the CDC affidavit for the eviction moratorium that's set through the new year?
That's a fantastic question. We don't know. And so for many cases, we're trying to use other defenses. So many people who would qualify for the CDC declaration moratorium would also be protected by the Tenant Safe Harbor Act. So we're tending to use the state law, which is a little bit easier to prove. You don't have to sign something where we can. In terms of what this means, what does the landlord do with this document? Who gets to see it? We don't know yet. But I think so far we haven't seen any real negative consequences for people who asserted that they're covered by the CDC moratorium.
And are there any special protections for seniors and or disabled people, disabled tenants? And what can adult protective services do to help at this time?
Unfortunately, there's no carve-outs about seniors or the disabled or people with kids. Anyone can be evicted if they kind of are along the path of a housing court case where an eviction can take place. It doesn't matter that you're more vulnerable to COVID, that you're elderly, that you have young kids, that you're disabled. You can still be evicted. However, these are the things that we need to point out to judges. We need to say, this isn't 2019. This is literally life or death. If you evict this person, they could die. And if you evict this person, other people could get sick and they could die. So this is a new time, and we have to make these arguments. We have to point these things out. And these are things that, if you talk to someone and they're unsure about how much to share, you should say, share as much as you're comfortable sharing, because judges are going to have to consider these factors. We're all in this together. And for the first time, we realize that housing and public health are tied together. So if we really want to fight COVID, we can't have anyone be evicted. And judges know that. Many judges have written decisions along those lines. And so we need to point those out. But to answer your question, there's no carve-outs. There's no one who is protected because they're elderly or disabled or they have kids. Anyone can be evicted right now.
For people in tenants associations, if the tenant association, for example, decides to go on rent strike or decides to do a group HP action, but there are one or maybe a couple tenants who choose to opt out of that, how does that, if you would know, how does that affect the tenant association's success?
So every tenant association is governed by its own rules, and those rules are up to the people who are part of that tenant association to create. Sometimes organizers will help tenants form tenant associations and come up with good rules, but there's no general rules for tenant associations. You can make it however you want. You can say 51% of us decide on something, then it applies to everyone. You can say it has to be 2/3. You can say anyone has the right to drop out at any time. You can say everyone's got to pay rent into this one account until we get what we want from the landlord, and then we hand over the money. Really, anything goes. But think of it like a private club. The rules can be whatever you set them to be, and hopefully they're fair and they're democratic, but it's up to the tenants. A lawyer isn't going to tell you what kind of rules you're supposed to have in a tenant association. We're just your spokesperson in court, and we can tell you what the law is, but the tenants decide how they want to run their tenant association. And in each building, there could be different rules.
If the housing court continues to set its course as it does now, meaning allowing evictions to resume in January, proceeding with non-payment and holdover cases, do we expect there to be a housing crisis as there was in 2008?
Well, let me correct that statement by saying evictions can take place now. There was an eviction in Brooklyn yesterday. And remember, there were tens of thousands of cases that were pending before March 2020. All those cases are now getting before judges, and landlords are asking people who were already going to be evicted before COVID to be evicted now. And some of those people are going to succeed. So evictions can take place. Cases that already started, there are already judgments, those people can be evicted. The second part is there going to be a housing crisis? Yes. There will be a massive housing crisis because there's this bubble that's growing bigger and bigger, where cases aren't being filed, rent isn't being collected, landlords can't sue to evict tenants for unpaid rent. And eventually something's going to give. Either we let the air out of the bubble by canceling the rent or increasing rent assistance to people, or the bubble just pops because there's so much pressure built up. And then we're going to see hundreds and hundreds and maybe thousands of evictions in January and February.
And so just for people, just to, for clarity, I know you've explained this before, but I think it is a very important point. We need to distinct the eviction moratorium and who it covers and who it doesn't. So if you could just go over that once again for everyone.
So that's a really good question. There's no moratorium right now. It expired already in New York State on November 3rd, if I'm not mistaken. Today is November 24th, right? So anyone can be evicted if they're at that point in their case. Now, who's going to be at that point in their case? Like I said, people who were sued before COVID, and those cases were in timeout for all these months. Those cases are going forward now, and those people can be evicted. Now, who is covered by the other kinds of moratorium, a moratoria? One, if you owe rent in the COVID period, then you can use the Tenant Safe Harbor Act and say, I can't be evicted for this rent that has become due since March 2020. If you owe rent in February 2020, you can be evicted, even if it's for 1 month. You could be evicted. If you owe rent before, like January or in 2019, you could be evicted. And similarly, if it's not about the rent, you can be evicted. So the landlord can bring a holdover case. They can say your lease is expired. They can say you're a nuisance. They can say you don't have a right to live there, that you never had the right to live there. All those cases can be filed and go forward. What is the CDC moratorium? Well, the CDC moratorium is something that the tenant can apply for. And on its face, it seems to apply to rent issues, like you can't pay because. So if it's not about the rent, again, you can be evicted if the landlord goes through with the case and gets to that point. So to reiterate, there is no ban on evictions right now. There are these laws that might stop certain types of people from being evicted, but there's no moratorium that applies to everyone like there had been up until November 3rd. Got it?
And so if we could just go over, how can people reach out to you guys if they're being sued in housing court? How can they get an attorney? I want to just show that.
Yeah, I think the number one way to try to talk to somebody is to call 311. Is that fair to say, guys, at Housing Court Answers? So if you call 311, you'll get connected to a housing hotline that the city set up. And it runs from 9 to 5, Monday through Friday. And it's staffed by people like me all across the city. And we answer questions. And in some cases, we take your case and try to help you navigate the eviction that you might be facing. So that's what I would recommend is call 311, get connected to the housing hotline. There are literally hundreds of lawyers and paralegals who are standing by. This sounds like a fundraiser or something. But there's literally, hundreds of us waiting to help you because we're not going to court. This is our work now, is to guide people through this maze of various rules and regulations.
Yes, and you can also call our hotline at Housing Court Answers. We're open Monday through Friday from 9 to 5, 212-962-4795. Don't worry, I'll put the information in the chat. And as someone mentioned in the chat before, yes, there are thousands of tenants are being sued and they're calling all of these hotlines. They've called our hotline. We got 1,200 calls yesterday. Also, 311's hotline, legal services housing hotline. So if you do call for assistance, please don't get discouraged if you have to call again or if you have to wait. Keep giving it a shot because understand that there are thousands of tenants across the city. We're even getting calls from people in other states that are worried about their own precarious situations, people upstate that are accidentally calling us because they need resources. So please, continue and we will get to you eventually. You can always reach out to us and I will put, if you could just let me share my screen real quick, I will put our information and I'm gonna leave my email here. If you guys, have trouble getting through our hotline, you can also email us and we can put you on our follow-up list. And so, one second. Okay, so never mind. So I'll just put our information in the chat, but please reach out to us at 212-962-4795. You may also leave us a voicemail. And so Jenna has a question that there are 2 Turnia cases. Okay, do we know when that might end and if that's going to continue, that the court will only hear 2-party cases?
Well, it's already ended. The court is now calendaring cases against tenants that are sued. But as Bill mentioned, right now, basically everyone's going to get a lawyer, no questions asked. So if you or someone you're talking to has been sued, just reassure them that they're going to be able to get a lawyer at some point in the process. If not immediately, they're going to get a lawyer, and the lawyer is going to help them navigate through the various protections that might apply, and at the very least try to delay the case as long as possible so that the tenant has as many options as possible.
Andrew has a really good question as well. Are there any plans that you may know of that the court is planning to manage the surge in cases, one dealing with the cases in the past and also these new cases that are getting calendared?
It's a great question. Personally, I'm not concerned about the court's ability to manage it because that's their problem. But I am concerned that the city continues to fund lawyers who can do this work. And so yesterday there was a hearing about the usefulness and how well the Universal Access to Counsel program is working. And that's the program that funds lawyers like me and hundreds of us across the city. So if you work for an elected official or you're an active constituent, tell your elected official, like, we need to keep funding this because there's this avalanche of evictions that's going to come, and we need everyone available to be standing there to help people when it does.
All right, well, I would like to thank you guys for presenting this information for us, for answering all of our questions. Again, if anyone here has more questions or about your specific case information, you can call 311, you can call our hotline. Please, be patient and keep calling us. Don't give up on us, because we are definitely here to help and assist all unrepresented litigants throughout the city. And so
there is one last question. Let's not ignore it.
Where is it?
Yeah, I mean, the question is, what about the landlords? And we hear about this all the time. And in Queens, we actually represent homeowners who have tenants and who are facing foreclosure. And it's not a issue that we take lightly. There are many landlords who are not corporations, who are not Jared Kushner, who are just trying to pay their mortgage and feed their family and make ends meet, and they happen to have a tenant in their downstairs, apartment. And so any kind of rental assistance should expand and increase to cover landlords who have to make mortgage payments. The money flows. If tenants get rental assistance, they pay the landlords pay their bills, they provide services, communities are strengthened, the city gets more tax revenue, everyone benefits. All ships rise when the tide comes in, whatever the saying is. It's, I am sensitive to that point, but what I'm not sensitive to is the corporate landlords who have made, billions of dollars in profits for decades and decades. I think they can afford a few losses for a couple of months. Another way to put it is, the real estate industry in New York is so big and so powerful that a second-rate landlord born and raised in Queens is for a short time more president of the United States, right? So I'm not worried about the landlords in New York, but I am worried about the small property owners, the mom and pops, the working people who happen to have a tenant or two. We need to look out for them.
I think it's also fair to say that the cancel rent movement was also, and is continuing to also call for the canceling of mortgages and for ease onto landlords, because again, as Satish said, we're all normal working people. Our money, our housing comes from our own pockets and our own struggle. We're not living off of thousands of tenants and having hundreds of buildings. So if you are a small landlord and you do need assistance, you can also call our hotline. So we, Housing Court Answers, assist unrepresented litigants throughout the city. So this includes tenants, this also includes small landlords, and we do have some resources, the few that they are, if you do have questions to call us about some mortgage relief information, you can call our hotline. Again, Monday through Friday from 9 to 5, and please be patient. Yeah.
So I'll put my email in the chat. And we will share the presentation. Oh, spelled it wrong.
Okay. All right. Thank you, everyone. Like I said, if you have any questions,